Everybody, good morning or good afternoon, wherever you are. Attendees are starting to file in as we've opened the webinar, but I'm going to go ahead and kick things off so that we fill our time in the hour that we have today. My name is Hillary Bricken. I'm coming to you from Los Angeles, and I have Griffen Thorne, also in our LA office with us, and Ethan Minkin in our Phoenix, Arizona office. And today, the three of us are going to be talking about current ketamine regulations and the future, at least in our opinion, of psychedelics, medicines, based on what's happening with ketamine, and essentially borrowing from the ketamine model, because collectively we believe that the pathway forward is probably going to look a lot like ketamine for these other psychedelic medicines at the end of the day. The first question, and I just want to say that over 280 people registered for this webinar, and the attendees are primarily made up of in-house counsel, attorneys. We have a few federal government delegates here from various agencies, chief medical officers, and various people across the healthcare spectrum that are joining today. So it's going to be a relatively high-level webinar. And please, as we go through, do ask your questions because they'll be sent to me over chat, and I will send them through and ask them of Ethan and Griffen as we go along. So the first question is, and just for anybody who might not know, or for those of you who do, essentially, what is ketamine? Unless you've been living under a rock, you know that it's a Schedule III controlled substance. It's typically used as a surgical anesthetic. That's its approved on-label indication. So you see it a lot in surgery, major surgery in hospitals. But it's also got an off-label capacity as a psychedelic medicine because it has psychedelic properties. Technically, some people would argue that it's not a psychedelic, but for all intents and purposes, because of this off-label application and its psychedelic effects, we're going to qualify it as a psychedelic today. And it's the only psychedelic that can actually essentially be prescribed. And we do have FDA-approved ketamine, which we'll touch on a little bit today, and its application with patients and how we're seeing it being used in ketamine clinics. But is ketamine federally regulated? The answer is yes, because it's a Schedule III controlled substance. And one of the follow-up questions that we got leading up to the webinar was, do states individually and independently regulate the administration of ketamine or the operation of ketamine clinics? And the answer is both yes and no. And we're going to get into the nuances of that because there's a difference between the medical judgment of the licensed practitioner that's administering or prescribing the ketamine, and then the actual operations of the ketamine clinic regarding storage of the drug, interactions with patients, malpractice issues, consent issues, etc. Generally, you're not going to see federal regulation on the majority of those things, other than maybe storage of the drug and registering to be able to prescribe the drug via the DEA. Otherwise, a lot of it is up to the individual state in how they license these particular facilities, but that's going to depend on what the drug is being used for and by whom. And each state will have a different licensing regime for that facility. States are even now breaking it down regarding licensed healthcare provider and who can administer ketamine. It's not always licensed physicians, MDs and DOs. Sometimes it's nurse practitioners or other licensed healthcare providers that can actually administer and or prescribe, or sometimes there's a collaboration agreement with a physician that's required. But that is going to differ on mostly a state-by-state basis rather than having an overall really intricate federal framework for how these clinics are run essentially day to day. Another question that came in essentially is, how is ketamine prescribed here? And this is basically this off-label capacity. And when we first began this practice, we get questions of how can physicians or healthcare providers even prescribe this drug for this use? The truth is, off-label use of a drug is actually really promoted in the United States. We want our healthcare providers to explore, investigate, and experiment with FDA-approved drugs for off-label indications because these are very intelligent individuals with lots of education. They may discover a pathway to treatment that hasn't yet been uncovered with on-label drugs. So typically, when you're going to a ketamine clinic, you are probably going to see some type of licensed healthcare provider for mental health issues and ailments. That's usually what we're seeing in the field, and Griffen and Ethan can talk about that, the variety of what we see. And the off-label application, primarily it's being used to treat treatment-resistant depression, PTSD, and other mood disorders that haven't experienced success with other on-label drugs. that is mostly what we're seeing in the field, mostly IV administration, with some of their oral administrations, lots of compounding pharmacy participation also to get the drug to market. But that's typically how it's prescribed. And just to transition away from the basics, another question that we got on the current regulations for ketamine is about the Ryan Haidt Online Pharmacy Consumer Protection Act of 2008. And I'm going to turn this over to Griffen, because what you guys are probably seeing in the marketplace is that a lot of psychedelics-oriented companies are advertising essentially being able to treat yourself with ketamine at home via telehealth, and the prescription of controlled substances like ketamine via telehealth or over the internet is highly, highly regulated. And there was a suspension in the law because of COVID, and I'll let Griffen talk about that, but things are going to change, ladies and gentlemen, for the online prescribing, at least of ketamine and other controlled substances, that will also have a bearing on the future of these other psychedelic medicines.
Hey everyone, thanks for the lead up, Hillary. Before addressing the question directly, I want to back up and sort of expand on a few of the points that you talked about. So the first question I think you raised was, how is ketamine regulated and licensed at the state level? And this is relevant to what I'm going to get into in a second. We've written about cannabis for the last 10 plus years as a law firm, and this is nothing like that. There's not. If the question was, is there, state licensing schemes and whatnot, the answer is no. What you see out there is state medical laws that apply, right? So if a state allows physicians to prescribe ketamine, then or any other controlled substance, the general medical laws of that state will apply. And again, to some extent, it's going to differ across the board. I'm not aware of any state that has a specific ketamine law, although I've seen some states that are trying to pass new laws that will essentially govern ketamine. A good example is Utah, which has a general anesthetic law that is being amended right now to address ketamine and certain requirements that have to be met to administer ketamine on site, like having special training, having special equipment, because, it is a drug. Unlike cannabis, it can be dangerous if it's not administered correctly, and so they want to make sure people have the proper training. In terms of how it's been administered historically, when we did these webinars initially, probably the beginning of or even before COVID, things were very different, right? So you had 2019, Spravato was approved by the FDA for treatment-resistant depression. Spravato is a esketamine. It's very similar in structure and function to actual ketamine, but it's a little different. And that is a nasal and spray that has to be taken in the doctor's office in the presence of, or whatever state law dictates, in the presence of the professional. The person takes it, has to wait 2 to 3 hours before going home. There's really strict guidelines for how the drug is administered. And at that time, you were starting to see a proliferation of ketamine clinics. And once COVID hit, what happened was, as Hillary mentioned, we have the Ryan Haidt Act, 2008 federal law that prohibits prescriptions via telemedicine, except unless one of a few exceptions are met. And one of those, the main thing about the Ryan Haidt Act is you had to have a prior in-person medical evaluation with a physician. So during COVID, that was suspended, right? So the administration realized that they wanted to give people the option to stay home and not travel to a physician's office to get routine prescriptions. And so that was just suspended across the board. That was the Public Health Emergency Declaration, or PHE declaration, you sometimes call it, which as of today, is still sticking around, whatever you may think of that, and will eventually end on May 11th. So up until now, for the last 3 years or so, and for the next month or so, actually a month exactly, the Ryan Haidt Act's provisions are suspended. For the last few years, you've just seen an explosion of companies coming onto the market doing ketamine via telehealth, various business models. Sometimes there's direct shipment to customers. You name it. There's a lot of different ways people have been doing it. And up until about a month and a half ago, nobody really knew what was going to happen. We all knew that the PHE would eventually end. There have been groups, not ketamine related specifically, but groups pushing the federal government to formally change things. One of the key parts about the Ryan Haight Act is it allows the DEA to make additional exceptions by regulation. And so there was this thought that, okay, maybe we can persuade the DEA to make an exception that basically keeps the status quo, because it turns out that it's very difficult for people to get prescriptions if they live in remote areas or don't have access to physicians for other reasons. And the DEA came out in late February with a proposed regulation that sort of splits the baby. What it does is it doesn't keep the status quo, and it also doesn't revert to the requirement to have a prior in-person medical evaluation. It creates essentially 3 exceptions to that requirement. The first is that for relationships established during the COVID-19 public health emergency, physicians can continue to prescribe for, I think, a 6-month period after the regulation comes into effect. The second exception is for just the initial establishment of a patient relationship. There can be up to a 30-day prescription of a non-narcotic Schedule 3 to 5 controlled substance. So that includes ketamine. And then the third bucket is if there's a referral from another DEA registered physician so essentially there's going to be an in-person requirement again, although the controls about that are sort of relaxed. It's not the best proposal. I mean, you see a lot of advocates out there saying that this is really bad. And look, I mean, if you wanted to keep the status quo, then it's not great, but it's better than just reverting completely to what we were at in 2018, 2019, and so on. And so, right now, the way that this is going to go is that DEA is considering public comments, which were submitted through end of March, and it will create its final regulation hopefully soon. I mean, the Ryan Haight Act will otherwise come back into full force on May 12th. If there's a gap in time, I'm not sure exactly what will happen at this point. I would imagine that the DEA is going to try to do something on an emergency basis to try to fill that gap, because practitioners aren't going to want to be in a spot where they're prescribing in violation of federal law. This isn't like cannabis where people just sort of like wink, wink and nod to federal law. Following this is very serious. Physicians could lose medical licenses. And so, we're all hoping that the DEA finalizes things by the 11th. But what that likely means is that they're not going to back off from that original regulation. It's probably not going to be changed. Or if it is, they'll do something on an emergency basis and continue to propose regulations on a long-term basis. But, only time will tell at this point. And it's, like I said, it's not the greatest situation in the world, but it's something.
Yeah, I agree with Griffen. I mean, it's the rule itself is, I don't think, overly complicated. The Federal Register release was 16 pages for the proposed rule. And anyone who's dealt with rules before in the rulemaking process, 16 pages is very short. I've had proposed rules that literally go hundreds and hundreds of pages. One thing I like about it, though, is at least for behavioral health, during this 30-day gap period, when it comes to behavioral health, there's only a requirement that you have an audio connection, not audio visual, because the DEA recognizes that, for mental health related disorders, it's primarily a verbal exchange between the patient and the provider, and that the provider doesn't need to really pick up on, different visual cues as you would in other type, treating other disorders. So I think there are some beneficial parts to this, and I think it's a decent compromise. The DEA is primarily concerned about diversion, drugs ending up in the wrong hands, and there are record requirements under the new rules too, and what you have to note in the medical record, which is to protect yourself too as a provider. So I would encourage people, if you haven't, to go ahead and take a look at the proposed rules. The discussion it's called the preamble to the rule, and that's really where the discussion is, and it gives the DEA's thinking and why they do certain things. And I agree with Griffen, and we're hopeful that the final rule comes out prior to the public health emergency lapsing. If we ended up in that gray area, I don't know what providers would do. I mean, I don't know if they would attempt to follow the proposed rule or abandon telehealth during this gap period, but hopefully it's something we won't have to deal with, because that does introduce a lot of uncertainty for the market.
Yeah, I also see a question in the chat box about, someone gets a prescription in that 30-day window, and then the 30-day window expires. Can they continue to take it? I mean, this rule governs prescription of controlled substances, and the 30-day window specifically is for Schedule 3 to 5 non-narcotic substances. So ketamine, for example, it wouldn't apply to something that's a narcotic. If a prescription itself, if someone still has it in their possession, I don't see why that would be triggered, but it's really the physician's prescription. And also, one other thing Ethan and I didn't mention, but I think goes without saying, is that this is just federal law. States are free to do things that are somewhat more restrictive than this. They can't be more lenient than federal law, so they couldn't allow prescriptions via telemedicine that were illegal under federal law. But that could provide additional headaches for practitioners, because a state might decide to do something that's more conservative than what the DEAs allow.
Right. And a lot of those states had their own suspensions of their telehealth laws regarding the prescription of controlled substances that have since expired. And many of them, the majority of them, so that they're not in conflict with federal law, required a synchronous initial interaction and physical exam to be able to prescribe after the fact over the internet. So the question for the two of you, and we get this from a lot of our ketamine clients, is now that this has come to pass and Ryan Haidt is going to be back in their lives, at least regarding the online prescribing of controlled substances, does this mean that companies that have providers in multiple states are going to have to set up a brick and mortar clinic in every state to initially see new patients or patients that exceed these times in the new proposed rule? What does it actually mean for effect and also for enforcement?
Not necessarily. I don't think the brick and mortar, the rules specifically allow for referrals from qualifying DEA registered practitioners. So, I think I can only imagine what people are going to do about referrals. I mean, there's obviously a lot of federal law and state law. Again, I always have to drum on the state law about referrals. Most of ketamine is not involved reimbursement, so some of those laws don't apply. But that's going to become a common thing for these companies. They're going to have referral networks. There may be brick and mortar establishments, but I guess only time will tell. Obviously, if you're in a really big state outside of a metro area, that just gets harder and harder to do.
Yeah, I agree with Griffen. I mean, yeah, it is nice that they recognize the exception that, if you see a provider that then makes a referral to a behavioral health provider, and that referring physician has, seen the patient in person, establish that relationship, then the behavioral health provider will be able to prescribe. But in the absence of that, the rules are pretty clear. You're going to have an in-person examination at some point. And that is cumbersome, as Griffen pointed out. I mean, we have a lot of people living in rural areas where there just aren't many, if any, providers. Some people have to travel hundreds of miles to find a provider or find a mental health or behavioral health provider. So, look, this is something the DEA can evaluate over time as well. I mean, nothing is ever set in stone. Rules are amended, statutes are amended. I think part of the whole purpose behind, these exceptions is to increase accessibility, right? I mean, that's really one of the pros of telehealth, is that, people have access to healthcare wherever they live now. And that is a real advantage. It is cumbersome, but, hopefully over time, the feds will be able to figure out, how to make this a little less cumbersome for people, especially those in rural areas.
Fair enough. Now, shifting the conversation just a little bit regarding other psychedelic substances. Are there other psychedelic substances that are going to be regulated, like ketamine, at least on this state by state treatment relative to different licensing? Obviously, we have Oregon, which legalized psilocybin service centers and facilitators, and that program has had a rocky start. But what about other psychedelic substances? Is it going to break like ketamine, or is it going to be like something else depending on the substance itself?
I think it makes sense to first talk about the service center model for a second and just like why that's not really relevant to this particular discussion. If you don't know, in 2020, Oregon passed a law called Measure 109 that authorized state licensed psilocybin service centers and related manufacturing facilities and whatnot, where people can go and consume psilocybin, which is a psychedelic mushroom, under supervision by a licensed facilitator. It's not a medical program per se. It's also not exactly like recreational marijuana because it's not take-home retail model, but it's this this facilitation center model, and that's sort of in some senses like what we're going to see with other psychedelics, which I'll get back to in a second. Colorado actually passed a law in the last general election, 2022, that's very similar. It hasn't come to licensing yet. That'll be either late next year or the following year. The big difference for Colorado is that it also relates to other psychedelics like DMT, and there may be a take-home component at the end of the day. But this is all in violation of federal law. So in that sense, it's sort of similar to marijuana. We don't know yet how the federal government's going to react at all. Like Hillary said, the rollout has been less than ideal. I think the idea of non-retail is just harder sell to businesses because it's not the sort of revenue driver that you get from being able to sell consumer packaged goods. Like it's a service, it's providing a service to people on site that probably is going to be more expensive than buying, a gram of cannabis. So in any event, that doesn't inform federal law at all. That's limited to these states, and in fact is an open violation of federal law. On the other end of the spectrum, there's sort of three buckets. You have a series of psychedelic substances that are just completely unregulated, right? You have, for example, there was like 5 different psychedelic synthetic drugs that the DEA tried to put on Schedule 1 last year and then backed off that. Those things may not be within the DEA's purview, but the FDA certainly can go after them and claim that they're adulterated, or that if they're sold with any sort of health claim or benefit at all, they would be unapproved new drugs. They do that sort of thing routinely with kratom, which is not psychedelic, but it's a drug that is also not in the Controlled Substances Act that the FDA routinely goes after. So yeah, any of these new psychedelics that haven't yet been scheduled or will not be scheduled doesn't mean that it's a free-for-all. I wrote a post this week on Amanita muscaria mushrooms, which the red caps with the white dots on them. I think that the FDA is eventually going to start looking at those. Now, the middle ground, which is why we had this webinar in the first place, which is these drugs that might be approved by the FDA very soon. Specifically, there's a couple of different formulations that are psilocybin-based, one that's MDMA-based. I know I'm probably going to catch a lot of flack for saying that including MDMA. Some people say it's a psychedelic or has psychedelic adjacent properties. So we kind of just put it in we blog about it on our psychedelic law blog a lot, which, as an aside, I highly recommend you all follow. But yeah, those drugs, so in the next couple of years, we will very likely have one or more approved psilocybin drugs and potentially an MDMA drug. They're very narrow. They will be approved for specific indications like PTSD or certain kinds of depression, very severe depression. But what we anticipate happening, of course, is like ketamine, there's going to be off-label prescriptions. What this likely will entail is rescheduling these drug formulations, not specifically psilocybin as a whole, but the approved formula from Schedule 1 to a lower schedule, likely 2, maybe 3. and there's a lot of ramifications depending on how they're rescheduled, which we could get into if there's any specific questions. But that's just sort of an overview of the future of psychedelics regulation.
Yeah, there are also a lot of clinical trials ongoing with MDMA and psilocybin. If you go to clinicaltrials.gov and just put in psilocybin, you'll probably have a couple hundred trials you're going to pull up. So, I don't know which one is closest to FDA approval, but there's a lot in the pipeline right now. And I think, I know there are at least some that are in phase 3 clinical trials, which is the large randomized trials. Phase 1 and phase 2 are usually very small scale. You're looking at things like safety and efficacy. But by the time you get to phase 3, you're pretty far along in the drug approval process. It's not guaranteed by any measure, but you've made a heavy lift to get to phase 3. I think it's also going to be interesting to see what happens with insurers. Once you have FDA approval, one thing that insurers want to make sure is that any drug they put on the formulary is efficacious, right? And that's part of the reason why we haven't seen ketamine added to formularies. I mean, there are some insurers, for example, Blue Cross Blue Shield of Massachusetts, that now will potentially approve the use of ketamine by their providers, but it requires a prior authorization and relates to behavioral health disorders. But when it comes to psilocybin and MDMA, I mean, I would be surprised if there isn't at least some insurance available. I mean, when you're an insurer, you're looking at the cost-benefit analysis. And if you can prescribe a drug, that's a lot less expensive typically than putting someone inpatient or in another facility. And, I know that at least one, if not both, have been classified as breakthrough drugs by the FDA, which means that they are far superior to anything that's currently on the market. So whether it's an antidepressant or another kind of drug, some of these psychedelics, have already received that breakthrough status. So I'm hopeful that we will see more insurance coverage because, again, it increases accessibility, right? Paying out of pocket for ketamine is typically not inexpensive. So if you can get insurance reimbursement, whether it's ketamine, psilocybin, MDMA, it will increase accessibility, and I think it will also, help with the disease state itself and keeping people in a proper setting, right? You don't want to go inpatient unless someone's very, very sick. There's the cost is much higher, and you have other issues once you go inpatient. And I also think, just to touch upon it, we'll see a similar model in terms of how clinics operate. Right now you have the corporate practice of medicine doctrine that generally prohibits lay individuals and providers from venturing together. And that same prohibition will apply to other psychedelics as well. So, we have what's called the friendly PC model, where it allows a lay entity and a professional entity to somewhat venture together. There's limitations, but that same model in all likelihood will continue to be used for other psychedelics.
Ethan, I wanted to ask you a question on this point about the insurance too. If we see like a psilocybin formulation, for example, that's approved for PTSD indication, and there's an off-label prescription, I mean, in your mind, will that change the potential coverage for insurance if it's prescribed for off-label?
It all depends on the insurer. I mean, there's a chance that, the insurer could cover it, but what the insurer is going to look at first and foremost is efficacy. There's not going to be large scale randomized trials for other indications because that's typically done by the drug manufacturer. And once they get a drug approved, there's really no reason to go get additional indications. I mean, there is a reason. You can market it then. You can't market off-label applications as a manufacturer. That's illegal and it's actually criminal. But at least in my experience, most manufacturers don't go back and look for additional indications to get approval. But there are studies and other things that can help to show efficacy. And it's also, the insurer would look at the local standard of care. Are other providers doing this out there? Is this really part of an accepted treatment regime? Because if not, the insurer is going to say, well, guess what? This is experimental and we're not paying for it. So coming out of the gate, I doubt there's going to be an off-label reimbursement piece. I mean, it's possible. I doubt it. But I think as time goes on and this industry evolves and there's more evidence of efficacy for other type of disorders, I can certainly see over time, insurance starting to, cover that. But out of the gate, I tend to doubt it.
I want to go back to Oregon for a minute to really paint the picture for attendees about what's been set up here, because it's frankly, it's quite unique in that we had a state legalize psilocybin, which is a Schedule I controlled substance. It's obviously in conflict with federal law. What happens to those service centers and facilitators once we get a psilocybin drug approved by the FDA? Can those programs continue to run parallel? Or are we going to see some kind of uptick in enforcement from the feds? Because now we have at least one drug maker with skin in the game with essentially a prescription drug for on-label indications. Meaning, how can the two coexist? Can they coexist at all?
I think there are some differences. First of all, I guess it goes without saying that we just don't know what the federal government's position is going to be just yet. With cannabis, there was something called the Cole Memo as far back as 2013 that indicated, the priorities the federal government would use in terms of enforcement with respect to cannabis. Honestly, nobody knows. As far as I understand it, people in the Oregon government have reached out to the Federal Department of Justice to ask, what's the deal here, and haven't, really heard back, at least publicly. So a big part of this, like with anything else, is just what are they going to do? Because again, Oregon's program is just an open violation of federal law. As of today, they haven't done anything about it, as far as I know. If the FDA approves a drug formulation, my understanding is that most of them are synthetically derived, whereas Oregon's program, I do not believe, allows for synthetic derived psilocybin. So there is going to be some differences. Also, I mean, Oregon's program is just very different in how it works. You don't have to be a physician. You don't have to have even gone to college to be a facilitator. You have to go through a licensure program and do some training. But it's going to be way more widely available, and so obviously more cost effective than it would be to get it prescribed by a physician, right? Unless you have coverage like Ethan was talking about. I think though, and I've written about this before, that the incentive for states to push through programs like Oregon's go way down if there's federal approvals for similar substances, because people can get that treatment. At the same time, if that federally approved drug and the treatment is incredibly expensive, then there still are some incentives for states to push this through. Like I said, Colorado has done the same thing. There was a couple of efforts to do this in Washington state that have to date failed. California proposed like a middle of the line decriminalization measure. Other states, probably very blue states, are going to try stuff like this, but I'm not sure we're going to see the need for a federal rollout, or state level rollout, the same way we saw with marijuana. Keep in mind also that marijuana and cannabis related drugs were approved by the FDA. You have Marinol, and that was a long time ago. And then more recently, Epidiolex, which is a CBD formulation, and that was in 2017. And as everybody knows, we've seen a massive increase in state level regulation of CBD following the approval of Epidiolex that has nothing to do with Epidiolex, right? Just like consumer products. So I'm not sure the FDA, the fact of approval is necessarily dispositive of anything, but it really just depends on how aggressive the federal government wants to be in terms of enforcement and whether they're going to defer to the state at all.
Yeah, I agree with Griffen. I mean, it opens up a lot of thorny issues, right? The conflict between state and federal law. And I mean, just thinking about the Oregon model, you have no provider, requirement to, I guess, prescribe, psilocybin. I would have to imagine the DEA wouldn't be happy about that. I mean, there are, again, strict regulations about the storage and security when it comes to any controlled substance. And, again, the DEA is primarily concerned about diversion. So I would sense that they wouldn't be very happy. Now, I don't know what the storage and security requirements are under Oregon law, but if I was involved, I would probably want to follow the DEA requirements, at least in that regard. But I think it'll be very interesting to see, what the feds do, if anything. And, I think part of it will be driven by, the administration too. I think a Democratic administration would likely, have a little more liberal view than potentially, Republican administration. But again, it's impossible to know right now. But I agree, there's going to be some thorny issues that are going to have to kind of be, ferreted out here.
And we did get one question.
Yeah, Oregon's model, I mean, it's been a really slow rollout. I think Hillary mentioned that. You can go and find data on this. Like, not a lot of people have applied since the license window opened up in January. And so it's just not been what you would see if there was an open cannabis application window in a different state, right? So it's going to be much smaller. I would still say, though, that it is incredibly regulated. It's not a free-for-all thing. And so it may be not at the same degree as DEA requirements for storage and whatnot, but there are tons of them, tons of different requirements. I mean, someone asked about inappropriate touching. Oregon has they've devoted entire sets of regulations to that issue. And a lot of these states have thought about it because you have someone who's in an incredibly vulnerable state under the influence of something where they're not in their normal state of mind. And so they can be easily taken advantage of. So states, when they regulate this, are thinking about that expressly. And I imagine the same issues would be present with federal approvals as well. So there's always that. And then, definitely outside the scope of this presentation, but I should just mention it quickly as well. There's a whole separate angle here in terms of religious use of psychedelics. There's Supreme Court precedent. I mean, we could do our own whole webinar on this issue, and maybe will in the future. And that would be completely outside the scope of all of what we've been discussing now. And in fact, already today, there are groups who've obtained those approvals. So, we know that there are instances where the DEA's own rules may not apply. And I'm saying that with a lot of caveats on it. But yeah, at the end of the day, only time will tell in terms of how the government reacts to this.
I didn't mean to gloss over this too. I mean, obviously the FDA is, may have concerns as well. I mean, you're essentially prescribing a drug that may not be approved at the federal level. And so, I think the FDA may have concerns as well, and they have enforcement authority. They can issue cease and desist orders. They can take you to court and seek an injunction and shut down a facility that's involved in the illegal, manufacture and distribution of a drug. So, I think both the DEA and FDA are, they're going to look hard at these issues, is what I would assume.
Right. And we did get a question that comes in that I think bears answering, although I think most of us will know the answer. But basically, if we have a drug formulation that involves a Schedule I controlled substance, if that formulation becomes FDA approved, does that automatically reschedule the substance, the illegal Schedule I controlled substance itself?
I'm not sure it would be automatic. There would be a rescheduling for that formulation, right? It would have to happen because you can't prescribe drugs that are on Schedule I. They're essentially off limits, and they can only really be commercialized, not even commercialized. They can be studied under very, very, very strict federal guidelines, and that obviously doesn't extend to physicians prescribing them. So it would necessarily need to be, that formulation would need to be rescheduled, not necessarily psilocybin writ large, but yeah, it wouldn't be automatic, and we just don't know as of right now what that's going to look like at the end of the day. Keep in mind that there's a very big difference between being on Schedule 2 and 3 and below, and I think at most what you'd see is this stuff going to Schedule 3, but more likely Schedule 2. because the government understand. The DEA doesn't like to give authority on these things. I understand their position. They think these things are dangerous, whether or not you agree with it. And so they're going to probably regulate this as much as they possibly can.
And one thing people can do too is, if I recall correctly, the DEA will issue an annual enforcement plan, and what they're going to look at, where they're going to focus resources. And so that may indicate what they're thinking about psychedelics right now. I haven't checked their plan for 2023, but those that are interested and they may be involved in the industry in one way or another, it's not a bad idea to check out the DEA's enforcement plan from year to year to see is this high on the radar or not.
But I do think kind of a global takeaway for everybody is that this is fairly unsettled, this culture conf basically between heavily regulated healthcare, development, dispensation and prescription of drugs versus more health and wellness over the counter, no licensed providers involved like we see in Oregon. And if the two shall coexist for as long as they do, who would drop the hammer in the event of enforcement? Would it be the FDA under the Food, Drug, and Cosmetic Act, the DEA under the Controlled Substances Act? Would it be both in tandem or more, including agencies like the Federal Trade Commission? We don't know. It's unsettled, but we do know that consumers and providers and policy folks and regulators are debating these issues fairly constantly about the future of these drugs. And that's why ketamine is so very interesting, because of this off-label application and the fact that it's a schedule controlled substance that can be prescribed. So what we do know is we have a roadmap with the FDA on how to handle psychedelic drugs. Obviously, I think the question becomes then, will the states continue to do what they do as basically laboratories for democracy and what voters want relative to these drugs? We can't know. And I don't think it's remotely similar to cannabis, and that's a bad analogy because these are such different substances. What I do want to talk about next, though, with the time that we have, is let's say it does break towards the heavily regulated healthcare regime that we have now for ketamine and other controlled substances that can be prescribed. The headaches that go along with that and the day-to-day operations, because we get a lot of questions at this point about what's the applicable standard of care, what should licensed healthcare providers be doing, what should their protocols and procedure paperwork say, what should their informed consent say, and so much of it is up to the healthcare provider and the rules of professional conduct and avoiding malpractice issues, that there's really no one standard fits all. And we have seen professional trade groups like the Psychiatric Nurses Association publish literature on how they think practitioners should conduct themselves relative to this off-label application, but there's no real gold standard. And I want to talk about first the corporate practice of medicine that Ethan mentioned, because that's in everybody's future that's going to do a brick and mortar clinic, a telehealth venture, anything related to ketamine. As opposed to, let's say, psilocybin in Oregon. And then I want to talk about litigation. I want to talk about where the courts are going to drive this regarding patient care standards, safety protocols, and malpractice issues, because we have seen some litigation come out already because we are in off-label land, which is not the Wild West. Obviously, it's regulated, but there's a lot of experimentation going on. So, Griffen, why don't you kick us off with the corporate practice of medicine, which we refer to as CPOM for short.
Yeah, this is a state law doctrine. Basically, I get calls once in a while from someone who says, "Hey, I'm in the cannabis industry. I want to open a ketamine clinic." And the first question I have is, "Are you a licensed physician?" Because in many states, California, where I live included, a layperson could not have any ownership interest in a medical corporation or partnership, right? So you need to look at state law to examine who can actually engage in the corporate practice of medicine, right? And states, there's basically an entire rainbow of patchworks of how states regulate this. In very regulated states like California, only physicians and certain other licensed healthcare pros can have any ownership interest whatsoever in a facility. Other states essentially don't have these requirements. I'm thinking like Florida is probably one of the looser ends. I think you'd agree with that, right, Hillary? And in states like California, what you end up seeing is all these models where you have the clinic on one hand, the provider company on one hand, so it's usually a professional medical corporation. On the other hand, you have a management services organization, a management company, or sometimes you call them like an MSO, and they are in contract with one another. And the physician's company does obviously the administration. It makes all the medical decisions and treatment-related decisions. It's responsible, like essentially the buck stops with them on anything regarding the regulated practice of medicine. And on the other hand, the MSO, which can be owned by basically anybody, will provide certain services to the medical professional corporation in exchange for money, right? And so people who come from the cannabis industry or maybe don't come from the medical industry want to pull as much as they possibly can out of the professional services organization into the MSO. And a lot of this is just looking at state law and determining what you can and can't do. There's case law on this in various states in addition to just general requirements of, let's say, the medical board. So here, for example, there's a decision that talks about fee splitting. There are statutes that govern fee splitting. I mean, this is incredibly state law specific, and what goes in Arizona, where Ethan lives and works, will just not be okay in any stretch in California. So one of the first things we talk about with people who are not, physicians themselves and want to be in the industry in some capacity is figuring out the state's law of corporate practice of medicine or prohibitions on that, and what workarounds, if any, there are. I mean, some states, just business models that people have just don't work. So it's really important for people to understand this stuff from day one, because at the end of the day, practicing medicine without a license can be a crime in some states, and the providers themselves can end up losing their licenses and having criminal fines levied against them as well. So not a situation anyone wants to be in. Medical boards are much more aggressive in terms of enforcement than other agencies might be. Just like, bar associations are very aggressive with enforcement against unauthorized practice of law. So very, very, very critical for companies to get a wrap around that before even negotiating a contract.
Yeah. I want to. Oh, sorry, Ethan. I just want to take it from the higher level. Basically, anytime you're going to be putting a needle in someone's arm under all statutes in all states, it's going to be considered the practice of medicine or the healing arts. That's why we're talking about this. So IV drips or prescribing drugs, you are in healthcare land. Whereas in Oregon, with these psilocybin service centers, physicians are not allowed to participate. So there is no corporate practice of medicine. It's a much easier corporate venture or financial opportunity than being with licensed healthcare providers. And this does not just apply to physicians. It applies to licensed healthcare providers, from family therapists to nurse practitioners. They're all captured, including dentists, for example. So it's very invasive, and it dictates the type of entity you can select to do business, who can be in the cap table, as Griffen mentioned, and every single state is different. And the governance documents that go into the entity that dictate what the company can and cannot do have to have specific magic legal language in them to comply with the corporate practice of medicine. So even that is heavily regulated. And then you've got your administrative or contractual relationships, as with an MSO. It's typically for management services or administrative services that do not constitute the practice of medicine. But that is a very wide array of decision making, or something that you might not think constitutes the practice of medicine actually does, even though it looks like an administrative process. So you have to look at the case law, you have to read the statutes if they exist, and then of course you also have to read attorney general opinions, which Ethan is very familiar with, to determine what is allowed in that particular relationship. And again, we face this with regulated healthcare ventures, as opposed to, for example, what's happening in Oregon with psilocybin. That's why it's relevant.
Mm-hmm. I was just going to pick up on the standard of care a little bit in litigation. I mean, these with regard to the standard of care with the FDA-approved or eventually approved MDMA and psilocybin, the clinical trials will have treatment protocols, right? You have to have those approved to, to then enter into the phase 3 clinical trials. So there will be a standard, at least, as to what is efficacious, and how that will work. Now, when you get outside of those particular drugs or formulations, that could be a different question altogether. But I think there's going to be, at least for those two particular drugs, there will be, even if you're using it a different non-approved, let's say, or you're using it for a different purpose, I think there will be a lot of guidance in the treatment protocols that have been, backed for the clinical trials. When it comes to litigation, I mean, I think you have to remember, if you're treating behavioral health patients, it's a high-risk population. I mean, unfortunately, people do commit suicide. Unfortunately, people do harm others. I mean, that's just a reality of being in the behavioral health field. I used to do a lot of risk management work for behavioral health clinics. And I can't tell you how many times I had to call the police with a duty to warn, where a patient would either make a subtle or more overt threat, to a third party. And so, I think providers need to be very careful when it comes to either ketamine or psilocybin or MDMA. We see in the ketamine field some providers who just aren't trained in behavioral health. Now, any physician, nurse practitioner, so on and so forth, could put a needle on someone. They're competent to do so, right? That's part of their training. But are they competent to treat behavioral health disorders? Now, if you have, say, an anesthesiologist, are they competent to treat behavioral health disorders? I mean, I don't know the answer. Maybe there's additional training they could do, online classes. But what we recommend to almost all providers is that if you're not a behavioral health provider, that you should ensure that your patient you're treating for behavioral health disorders is also seeing a therapist or receiving other form of, treatment. Because there's a whole continuum in behavioral health. It's not just the administration of a drug and you walk away and everything is wonderful again. And so those providers that just put a needle in someone's arm and, the patient leaves at the end of the day and there's no follow-up, there's no other providers involved, those I think are very high-risk situations. And I think that, they're looking at malpractice-related issues. One thing I would highly recommend to any provider in this space is talk to your malpractice insurer. They have risk management departments, and the risk management department is there to make sure their insureds don't get sued. And so, I would speak to that department if you have questions. I would speak to that department and see if they have policies and procedures and recommendations for how to run these type clinics. Because, unfortunately, malpractice is prevalent and it's expensive and it's distracting. And if you end up, with a verdict against you, that gets reported to the National Practitioner Data Bank. And that has horrible consequences for a provider. So, we preach a lot about this particular subject, but I think it's really one that providers need to take very seriously, to avoid these type issues. And even if you do all the right things, again, it's a high-risk population, and unfortunately, bad things are going to happen. I mean, it's just not preventable with behavioral health, where people, whether it's major depression, whether it's PTSD, I mean, it's just an unfortunate, thing that happens in this field. And then, Hillary pointed this out as well. There are some trade groups that have made some recommendations about, treatment protocols, the standard of care. To our knowledge, there's not one national one that's been adopted, and, a lot of it's going to be driven also by the local standard of care. And, hopefully over time, as things evolve and people get more familiar with these substances, we will have more standardized, treatment protocols, which again, I think, that again will help reduce the risk of malpractice. Without a treatment protocol, without a standard of care, it's very difficult. And it's very difficult to protect yourself. And so I think over time, these things will evolve.
I agree with that. And we have seen a recent uptick in the types of providers that are coming to us that want this kind of venture in their lives. And I think a lot of providers, mistakenly or not, see it as a cash cow because of the out-of-pocket relationship with the patient and the fact that insurance companies are increasingly flirting with picking it up. But the majority of the providers that we've talked to, at least recently, they have no psychiatric training. They have no therapeutic training. And who's to say what the baseline is for competency anyway if they were to acquire it? We can't say, but Ethan's right. 9 times out of 10, we're going to tell those providers, whether it's a general practitioner, family healthcare, anesthesiologist looking for a side hustle, that there needs to be a therapeutic component, and how they choose what that is and to the degree of what that is. I also agree that talking to your malpractice provider is going to be the best way to go. They may even already have established procedures for off-label protocol that you can utilize without having to spend too much money with legal to try to figure it out. But we have seen that uptick occur. And the other kind of trend that we see within regulated ketamine and other psychedelic substances is that many companies that started in cannabis have jumped into the psychedelic field, and they want ketamine as part of their portfolio, so that once these other psychedelic substances are approved by the FDA, they can offer the entire suite of psychedelic services, and they're building branding behind that and goodwill and trademarks. There's a whole rhyme or reason to why they've attacked this particular market, because ketamine clinics have been around since 2015. But they've really only increased in number very recently on the back of psilocybin and on the back of the approval of things like Spravato. But it bears mentioning because a lot of those companies are clueless about healthcare regulations in the United States, and they're going to get providers in trouble. And it's not like the majority of providers understand corporate law around these things, or even necessarily the regulatory beyond DEA expectations and obligations. There's just a lot of education that has to take place, is the bottom line. Okay. So guys, we've got 4 minutes left. Any parting comments for our audience?
I would just say something to look out for, just to circle back to it, since someone raised this as a comment in terms of litigation, is this issue of consent and touching. It's a really thorny issue that you're just not going to see with lots of other forms of medicine. And Oregon, actually, again, this is not the practice of medicine. This is just Oregon's therapeutic model, or their adult use model, however you want to refer to it. You know, they have rules about consent, which I think are actually pretty good if you look at them. You know, consent to touching and things like that. You know, there's physicians aren't going to be able to record sessions in most cases, and maybe having multiple people in to make sure that that happens is a concern that they can consider. I mean, obviously, it may be cost prohibitive given that some of these substances have very, very long effects, 4 to 6 hours, for example. So these treatments really present new and different considerations from what we have. I mean, ketamine is a lot simpler, I think, than, let's say, psilocybin, just because oftentimes people can get an infusion and sit in a chair for you know, an hour to a couple of hours, and don't need the kind of constant monitoring that you might need under psilocybin, for example. But yeah, a lot of this just remains to be hashed out at the federal level. It bears mentioning 2 points: that there is always the possibility of federal regulation, federal law changes by Congress to address some of these issues. But, you know, as we all know, Congress can't basically legislate anything. And then, you know, the DEA historically doesn't really like to give up authority over drugs. I mean, we saw that with hemp when it was descheduled, and various cannabinoid formulations that came out of that. So I would expect to see the DEA try to rein back some excessive practices. And if, you know, if there is some sort of federally approved drug formulation that has psilocybin, there's probably going to be some shenanigans with at least some providers, and we may see some blowback to that at the federal regulatory level in the coming years. So the next decade is going to be really interesting, I think. A lot remains to be seen, but yeah, TBD.
Yeah, I agree with Griffen. I mean, I think, you know, this industry, there's a lot of new and thorny issues that it's going to take time to figure them out and for things to settle down. psychedelics are somewhat disruptive. It's new to the industry. It's something that used to be taboo, but there are a lot of legal issues that kind of surround this industry that it's going to take a little time to get our hands around. And so I would just caution providers to be vigilant, to keep their eye on the press, to keep their eye on the healthcare news when it comes to this type of, and there are, ketamine associations for providers, and it's probably not a bad idea to take a look at their literature and their advice as well. And, to the extent it could apply to other areas like, other forms of psychedelics, but be vigilant. That's the best advice I can give.
All right, gentlemen. Well, we're at the hour. Thanks everybody for your attendance and your attention. We always appreciate it. And we'll see you on the next one.